Right. Good morning, students. Let's settle down and get straight to it. Today, we are cracking open a highly probable question for your upcoming KSU examinations. I want you to write this exact question number, Q25, dead center at the top of your answer script. Discuss the Constitution, powers, and functions of family courts under the Family Courts Act 1984. This is a classic 16-mark question, and in today's Masterclass Explainer, we are going to deconstruct exactly how you must structure your answer to command absolute authority and secure maximum marks from the evaluator.
For our synopsis, we will be covering the introduction to family courts, the Constitution under the Act, civil and criminal jurisdiction, powers and flexible procedures, a landmark case law analysis, and finally, advantages and concluding remarks.
Section 1. Introduction to Family Courts.
Now, do not underestimate the power of a solid synopsis. Writing those exact 6 headings on the first page of your booklet provides the evaluator with a very clear roadmap. Every major 16-mark answer absolutely must begin by establishing the legislative intent of the bare act. You need to explicitly state that the Family Courts Act of 1984 was enacted to provide speedy and amicable settlement of family disputes, aiming to promote conciliation rather than adversarial litigation. Let's deliberately dissect those terms for a second. Why did the legislature use the phrase amicable settlement and conciliation? Well, because traditional civil courts are inherently adversarial. It's a battlefield, right? Winner takes all. But in family law, if one spouse wins and the other is utterly destroyed, the family unit, the children, they suffer irreparably. So the introduction of this act shifts the entire paradigm from fighting to healing. You must highlight the word conciliation in your answer script.
Moving on to Section 2. Constitution under the Act.
Listen carefully. The evaluator is scanning your paper specifically for digits here, so you must underline every single section number. Note these 3 points precisely. First, establishment under Section 3. The state government establishes family courts in cities with a population above 1 million, or in other areas as they deem necessary. Second, appointment of judges under Section 4. Judges are appointed by the state government, but here's the key. They must have not just legal experience, but a demonstrated commitment to social welfare. Third, association of experts under Section 6. The courts may involve counselors and social welfare agencies. Students, notice the progression here. The KSLU evaluator is looking for Sections 3, 4, and 6 in exact sequential order. If you jump straight to powers without explaining that the judge under Section 4 needs a social welfare background, you are going to lose critical marks. This isn't a standard civil court. It is uniquely constituted to include psychologists and counselors under Section 6. Write it exactly like this.
Section 3. Civil and criminal jurisdiction.
This is a highly critical conceptual area. A lot of average students just assume family courts are purely civil. Please do not make that mistake. I highly recommend you literally draw a 2-column table in your answer script for this. On the left side, put civil jurisdiction under Section 7. This covers matters like marriage and divorce, maintenance, the legitimacy of children, and guardianship and custody. Then, on the right side, put criminal jurisdiction. This includes proceedings under maintenance laws, specifically Section 125 of the CRPC. Let me meticulously explain why this matters. Section 7 of the Family Courts Act consolidates all civil matrimonial disputes under one single roof. But the legislature also handed a criminal jurisdiction specifically for CRPC Section 125, which deals with the urgent maintenance of wives, children, and parents. By drawing this table, you visually demonstrate to the examiner that you truly grasp the hybrid jurisdictional capacity of the family court.
Section 4. Powers and flexible procedures.
Pay very close attention here, students. You absolutely must emphasize procedural independence, because this is exactly where average students drop marks. First up, civil court powers. The court has the exact same powers as a regular civil court. It can summon witnesses and receive evidence. But here's the twist. Flexible procedure under Section 10. The court is not strictly bound by the Civil Procedure Code or the Indian Evidence Act. It can adopt informal procedures. Finally, in-camera proceedings under Section 11. These proceedings may be held privately to protect family dignity. Let's elaborate a bit. The departure from the strict Civil Procedure Code under Section 10 is revolutionary. If a family court judge wants to sit across a table and talk to the husband and wife over a cup of tea just to get to the truth, they can do that. They aren't suffocated by the rigidities of the Evidence Act. Furthermore, Section 11 mandates that, upon request, hearings are held in camera, meaning behind closed doors. Family disputes involve incredibly sensitive, intimate details. Protecting the family's dignity is absolutely paramount.
Continuing with procedures, we have the emphasis on settlement under Section 9.
The court is mandated to attempt conciliation and settlement. And crucially, this is a big one, exclusion of lawyers under Section 13. Lawyers are generally not allowed as a matter of right. The court might permit them, but only if absolutely necessary. Section 13 is a very unique statutory mandate. You have to fiercely emphasize this in your exam. Why exclude lawyers? Well, because we lawyers are professionally trained to argue, right? To find loopholes, to win cases. But in a family court setting, the goal isn't to win an argument. The goal is reconciliation. Section 13 actively prevents cold legal technicalities from overpowering human familial reconciliation. The parties are encouraged to speak for themselves.
Section 5. Landmark Case Law Analysis. I like to call this section the mark scoring arsenal. While just knowing the bare act gives you a passing grade, integrating landmark precedents is what elevates your answer to a distinction. First case, K.A. Abdul Jalil v. T.A. Shahida. This held that family courts have incredibly wide jurisdiction in family matters. Now, don't just name-drop the case. You should physically draw a box around this case name on your paper to immediately grab the KSLU evaluator's attention. Let's expand on the background and the ratio decidendi here. In this landmark dispute, the question came up, could a family court adjudicate a property dispute between a husband and wife after they were already divorced? The technical argument was, well, since they're no longer married, it's just a standard civil property dispute. But the Supreme Court stepped in and said no. The jurisdiction of the family court is exceptionally wide. If the origin of the property dispute stems from the marital relationship, the family court retains jurisdiction. This case brilliantly proves the expansive, specialized power of these courts. Box it, explain the ratio, and secure those marks.
Our next vital case is S.D. Joshi v. High Court of Bombay, which emphasized the importance and special nature of family courts. I want you to underline this case name heavily. The facts of S.D. Joshi are fundamentally about the pedagogical nature of family judges. The core legal challenge centered around who is actually qualified to sit as a family court judge. The Supreme Court profoundly broke down the relevance of Section 4 here. They noted that an ordinary, even brilliant civil judge might still be totally unfit for a family court if they lack a socio-legal approach. The court ruled that dispensing family justice requires a unique sensitivity, a deep psychological understanding, and a genuine commitment to saving marriages, not just mechanically applying dry law. This case is your ultimate proof of the special nature of family courts.
Section 6. Advantages and concluding remarks.
This is where we guide the evaluator into the final phase of your answer script. You need to neatly tie all the statutory provisions together. List these advantages with absolute authority. 1. They promote conciliation and reconciliation. 2. They provide speedy justice and disposal. 3. They protect family relationships and ensure child welfare. 4. They significantly reduce the immense burden on our regular civil courts. And 5. They utilize a less formal procedure strictly focusing on settlement over conflict. Students, this bulleted list essentially synthesizes the statutory functions of Section 9 and the procedural flexibilities of Section 10 into one cohesive evaluative checklist. It proves to the examiner that you understand not just the letter of the law, but its practical, functional utility in our society.
Let's finish strong. Your conclusion should read something like this. Family courts play a vital role in resolving disputes with sensitivity and efficiency. Their focus on reconciliation and simplified procedures ensures justice with compassion. This statement right here is the perfectly balanced closing for the KCSLU marks allocator. It uses exactly the right academic vocabulary, words like sensitivity, efficiency, reconciliation, and compassion, to elegantly summarize the entire spirit of the 1984 Act.
So, I leave you with this provocative challenge. How will you synthesize these statutory mandates, from Section 3 all the way to our landmark rulings, to command absolute authority in your 16-mark KSLU finale? The structure is clearly laid out for you. The case laws are boxed, the sections are underlined. It is now entirely up to you to write this with precision, memory, and intense academic rigor. Master this framework, replicate it in your exam hall, and you will undoubtedly dominate your examination. Dismissed.